My name is Jessica Tankersley-Sparks. I am the supervising attorney at Fair Housing of Marin, and I will be presenting today's training on fair housing law and practice. For today's training, we'll start with a brief overview of fair housing in Marin. Then we'll talk in depth about federal and state fair housing laws. We'll have a breakout session of the training focused specifically on disability discrimination and reasonable accommodations. Then we'll conclude the training by talking a bit about the administrative complaint process and how to develop proactive fair housing policies. Fair Housing of Marin is a local fair housing organization. Our offices are in San Rafael, and we serve Marin County as well as Sonoma County and Solano County to an extent. Our mission statement is to ensure equal housing opportunity and to educate the community on the value of diversity in our neighborhood. At Fair Housing in Marin, we provide counseling and investigation of discrimination complaints. We also offer community education, and we undertake audits or systemic testing designed to measure whether housing providers are complying with fair housing laws. One of the questions that I field most frequently when talking about fair housing is, what does fair housing mean? Oftentimes people call our organization. They say, my landlord won't fix my plumbing, or my housing provider is raising my rent, and it's just not fair. But fundamentally, the issue of fair housing is about ensuring that people have equal housing opportunity or equal access to housing choice, regardless of some immutable characteristic, a personal characteristic like race or national origin or disability. When we talk about housing discrimination, it's often helpful to illustrate with statistics about what types of complaints people bring. HUD's most recent complaint data illustrates that nearly half of discrimination complaints are based on disability discrimination. Rounding out the rest of the most frequent bases for complaints are race, familial status, and national origin. The statistics we have at Fair Housing and Marin are similar. The majority of our cases, more than half of calls, are related to disability discrimination. We also field a number of national origin, race, and familial status complaints. There are 4 federal laws which cover fair housing. We'll talk about each of them to an extent, but we'll focus primarily on the Fair Housing Act. The 4 laws in question are the Civil Rights Act of 1866, the Fair Housing Act, or the FHA, the Rehabilitation Act, and the Americans with Disabilities Act. In California, we have 3 additional state laws which also prohibit housing discrimination. The California Fair Employment and Housing Act, or FEHA, the Unruh Act, and the Ralph Civil Rights Act. The Civil Rights Act of 1866 was passed after the abolition of slavery. It was designed to protect the rights of black citizens to own property. It was the United States' first foray into addressing housing discrimination, and it was later expanded to also cover national origin discrimination. The Civil Rights Act of 1866 is significant because for nearly 100 years, it was the only source of codified prohibitions against housing discrimination. The scope of the protections under this law are narrow. Because the law only speaks to race or national origin discrimination in housing, it's not often the primary source of contemporary fair housing claims. However, even though the scope of the law is narrow, it can be a powerful enforcement tool for 2 reasons. 1, because there are no exemptions to this law. 2, because there is a 3-year statute of limitations. As you'll see when we talk more specifically about the Fair Housing Act, both the absence of exemptions and the long statute of limitations combine to make the Civil Rights Act of 1866 a powerful enforcement tool. For nearly 100 years, the Civil Rights Act of 1866 was the only law in place that prohibited discrimination in housing. In 1968, however, the Federal Fair Housing Act, otherwise known as Title VIII, was passed. It was passed 4 days after the assassination of Dr. Martin Luther King Jr. And the Fair Housing Act, or the FHA, is one of the key federal civil rights laws. It's the direct outcome of the equal rights movement spearheaded by social activists in the 1960s. The Fair Housing Act represents a considerable expansion of previous protections against housing discrimination. When it was enacted in 1968, the Fair Housing Act originally prohibited discrimination in the sale, lease, or purchase of property because of a person's race, color, or national origin, or their religion. In 1978, the law was amended to include protections against discrimination based on sex or gender. The Fair Housing Act is now interpreted to also protect against discrimination on the basis of gender identity. And in 1988, the Fair Housing Act was amended again to include prohibitions against discrimination because of familial status or disability. Familial status means that there are minor children in the home. These protections extend to adopted or foster children, grandchildren, and pregnant women. People without children are not protected from discrimination under this provision. Disability means both mental and physical disabilities. So, to recap, the Federal Fair Housing Act protects on the basis of race, color, or national origin, religion, sex or gender, familial status, and disability. In California, our state Fair Employment and Housing Act adds additional protections. It incorporates the 7 protected classes under federal law and includes protections against discrimination based on marital status, sexual orientation, ancestry, source of income, or gender identity or expression. A second state law, the Unruh Act, also adds prohibitions against discrimination based on any arbitrary characteristic, meaning any characteristic that's not reasonably related to somebody's ability to be a good tenant. Most often, this comes in the form of discrimination based on age, occupation, potentially veteran status, or student status. I should note that source of income protections apply specifically to income that is lawful and verifiable. In California, there are no protections based on receipt of a Section 8 housing choice voucher. This means that in California, it is legal for a landlord to decline to participate in the Section 8 program. We've talked about who is protected from housing discrimination. Let's focus now on when the law might apply. Anything considered a dwelling unit will be covered under fair housing law. Dwelling units are broadly defined as anything occupied or designed as a residence. This covers traditional housing like single-family homes and multifamily complexes, but also covers less traditional properties. For example, mobile home parks, timeshares, nursing homes, group homes. Many types of homeless shelters may be covered under fair housing law. With less traditional types of housing, the question is whether the property is an abode to which the individual intends to return. For a homeless shelter, for example, some of the questions used to determine whether it falls under the definition of a dwelling unit might be, can a person store their belongings in a locker during the day? Can they reserve a bed? Anything that's considered a dwelling unit will be covered under state or federal fair housing law. Federal and state law carve out several clear exemptions to fair housing coverage. 3 exemptions are paralleled under both the Fair Housing Act and FEHA in California. Let's focus on those exemptions to start. Any nonprofit religious housing that's used for the church or charitable association itself, meaning it's not on the rental market, will be exempt from the religious discrimination prohibitions of fair housing law. For example, if a Catholic church has a small apartment unit behind the church building itself and reserves that unit for the priest to live in, that property would not be subjected to the religious discrimination provisions of fair housing law. As you can see, this is a very narrow exemption. Another exemption that exists under both federal and state law is for gender-segregated college dorms. Gender-segregated college dorms, the men's dorm and the women's dorm, are exempt from the sex discrimination prohibitions of either state or federal fair housing law. A third exemption that exists under both state and federal law is for bona fide senior housing. Bona fide senior housing is exempt from the familial status discrimination prohibition. This means that bona fide senior housing can lawfully decline to rent to families with children. But what is bona fide senior housing? Bona fide senior housing means that the property meets both an occupancy threshold and an intent requirement. The occupancy threshold means that either all residents of the property are aged 62 or older, or 80% of residents are 55 or older. The intent requirement means that the purpose of the property is to house seniors, and that the complex makes public and abides by its policy of providing housing for seniors. If either of these two factors are not present, then a property will not be considered a bona fide senior housing facility and will not be able to lawfully decline to rent to families with children. Federal and state law differ on the final category of exemptions. Under federal law, owner-occupied housing with 4 or fewer units will be exempt as long as the owner does not advertise or make discriminatory statements. And under federal law, a single-family home that is sold or rented by the owner herself without the assistance of an agent or a broker in a situation where the owner is not a professional housing provider, meaning she's not engaging in more than 3 residential real estate-related transactions at a time, will be exempt from federal law. However, these exemptions do not carry over to state law. Under California state law, the only other exemption that exists is for an owner-occupied, single-family home that sublets to only one other person. The law around advertising and making discriminatory statements at properties that would otherwise be exempt from the Fair Housing Act is a bit of a gray area right now, but the exemption is clearly established for an owner who is subletting one room to one other person who does not make discriminatory statements or post a discriminatory advertisement. I should note that an owner who is subletting one room in her home may lawfully express a preference for a roommate who is of the same gender. And this is if there are shared living facilities like a shared kitchen and shared bathroom. So who can be held liable for violating fair housing laws? There are the obvious actors: property owners, landlords, and managers. But then there are other less immediately apparent parties, such as maintenance staff, like an on-site maintenance man who routinely leers at single female tenants and sexually harasses them when they request repairs to their units. Administrative staff may be liable. An example of this is a front office person who answers phone calls from prospective tenants. If that office person is impatient with callers with heavy accents and just refers those callers to the website instead of providing information over the phone, that office person could be liable for national origin discrimination. Real estate professionals may be liable for discriminating against homebuyers or for acting on a homeowner's discriminatory instructions. For example, a homeowner who tells a real estate agent that he doesn't want to sell to a black family. Lenders, appraisers, and insurance brokers may be liable. Homeowners associations may be liable for implementing discriminatory policies, like having CC&Rs that restrict children from playing outside, or refusing to hold HOA meetings in an accessible location. Architects, builders, and developers may be liable for accessibility violations, constructing buildings that are not accessible for people with physical disabilities. And finally, municipalities or local government entities may be liable for violations of fair housing law. This includes counties and cities. It also includes public housing authorities or other organizations under the umbrella of municipal authorities. They can be liable for having discriminatory policies, like zoning ordinances that do not allow for the development of group homes for people with disabilities. They can also be liable for failing to meet their obligation to affirmatively further fair housing. And we'll talk about affirmatively furthering fair housing in more detail in a subsequent portion of the training. There are two ways an individual can show that a right to fair housing has been violated, either through disparate treatment or disparate impact. A showing of disparate treatment means that there's evidence that an individual was treated differently because he is a member of a protected class. There's no requirement of intent. There's no requirement that a landlord or a property manager was motivated by bias or intended to discriminate. The requirement is just that the housing provider intended to take that specific action. An example might be a general policy of charging increased security deposits for people in wheelchairs or for families with children, under the logic that those groups are more likely to cause significant property damage. Even though that policy is not designed intentionally to discriminate against people in wheelchairs or families with children, it is an intentional policy, and thus it would be evidence of disparate treatment. Disparate impact is a different theory of liability. The disparate impact theory states that there is a policy or practice that is neutral on its face, meaning that it doesn't reference any protected class, and has been neutrally applied, meaning that it's applied across the board, but that policy or practice has a disproportionately negative effect on members of a protected class. Now that we've talked about who is protected under fair housing laws, which parties might be liable for violating those laws, and what types of properties are covered, let's focus specifically on the types of activities that are prohibited under fair housing law. First, it is illegal to refuse to rent, sell, or negotiate for housing because of a person's membership in a protected class. An example of this might be a leasing agent who never returns phone messages from prospective tenants with heavy accents, demonstrating some linguistic profiling or national origin discrimination. Another example might be a property that has an independent living requirement, refusing to rent to seniors or people with disabilities unless they demonstrate that they can live independently. A third example might be a landlord who refuses to rent to a family with children. An example of this based on a complaint that we had at Fair Housing in Marin. A landlord told an applicant, who was a single mother with a child, that she couldn't rent a one-bedroom apartment with a loft because the landlord thought it wasn't safe enough for a child and didn't have enough room for a child to play. Fair housing laws protect a tenant or an applicant's right to determine what type of housing best fits their needs. A landlord does not have the right under the Fair Housing Act to arbitrarily restrict a person's choice because of, quote, safety concerns. Fair housing laws also prohibit offering different terms or conditions because of a person's protected class. For example, only offering move-in specials to white tenants. It's unlawful to make false representations about availability, like telling a black applicant that an advertised unit is no longer available when it is in fact available. It's similarly unlawful to refuse to make necessary reasonable accommodations or modifications, and again, we'll focus on this in more detail when we talk specifically about discrimination based on disability. Harassment and retaliation are expressly prohibited under fair housing law. This includes intimidation and coercion, for example, threatening to evict a tenant who complains about a property manager who sexually harasses her. This also includes retaliation, specifically retaliation against somebody for exercising their fair housing rights. Most often, this is in the context of making either a formal or an informal housing discrimination complaint. For example, if a tenant files a HUD complaint alleging housing discrimination, then a landlord decides that tenant is a problem tenant and gives them a 60-day notice to terminate. That would be considered retaliatory. And the presumption in California is that any negative action taken within 6 months of an individual's exercise of their fair housing rights is retaliatory. Discriminatory statements or advertisements, including statements that indicate a preference or limitation based on membership in a protected class, are unlawful. The person or the entity that makes the statement or writes the ad is liable, but also the entity that publishes the ad can be liable, like a newspaper, if there's the opportunity to exercise any editorial discretion. So a newspaper that exercises oversight of ad content before publishing ads could be liable for violating the Fair Housing Act, but Craigslist, for example, would not be liable for a discriminatory ad because Craigslist does not approve any content before ads go live. So what type of advertising is covered? Words and phrases that communicate preferences or limitations are clearly included under this category. Phrases like "no kids allowed" or "single quiet professional wanted" communicate very clear preferences about members of protected classes and who may or may not be welcome at a property. But symbols or illustrations can also be considered discriminatory advertising, as can human models. The human models example is drawn from a lawsuit against the New York Times in the 90s. That lawsuit was based on a full-page ad for a new housing complex, which used only white human models, pictures of white people, to communicate about the availability of the property. Those human models sent a very clear message about who would be welcome in the community. The discriminatory effect of that advertising was compounded by the fact that the racial and ethnic demographics of the target market of that publication were incredibly diverse and clearly not representative of the human models used in the advertisement. Some of the best practices that we recommend for housing providers include focusing on a description of the unit itself, not the person that a housing provider wants to live in that unit. This means providing information about the home's location and amenities, the lease terms, the application and qualification criteria, and leaving the decision about whether it would be a good fit to the individual home seeker himself. Steering is another practice that's expressly prohibited under fair housing law. Steering is the practice of arbitrarily restricting a person's choice in housing opportunity based on their membership in a protected class. At the time of the enactment of the Fair Housing Act, this was primarily in the context of racial steering. For example, a real estate agent who showed equally qualified homebuyers housing in different neighborhoods based on their race. Steering is now also relevant in both familial status and disability cases. It may mean steering families with children to first-floor units or people with disabilities to different complexes. An example might be a property manager who says, well, this property wasn't really designed for children, but there's a complex about a mile away that's close to a playground. It would be a much better fit for your family. Blockbusting is also expressly prohibited under fair housing law. Blockbusting was prevalent in the 1940s and 50s. It was a practice by real estate agents of encouraging white property owners to sell their homes, usually at a loss, by preying on fears that racial or ethnic minorities were moving into the neighborhood and about to depress the home values. Agents or developers profited off of a fire sale mentality. Finally, federal and state fair housing laws prohibit discrimination in lending. This includes discrimination in the terms and conditions of mortgage loans, such as the practice of redlining, where a lender literally blocked out neighborhoods with high minority concentrations in red ink on a map, and noted areas where that lender would refuse to make mortgage loans. It also includes the appraisal and insurance industry. The Home Mortgage Data Disclosure Act requires that lenders actually publish the data on their loans that they've made and the applicants for loans based on race, sex, and income. In addition to expressly prohibiting the aforementioned activities, Federal fair housing law also requires any recipient of federal funding to affirmatively further fair housing, or AFFH. Let's talk specifically about this obligation for a few moments. AFFH requirements mean that federal grantees, anyone in receipt of federal funding, must actively promote residential choice and integration. Federal funding includes community development block grants, CDBG funds, emergency shelter grants, housing opportunities for people with AIDS. It also includes public housing authorities. All of these entities are obligated to certify that they are undertaking proactive measures to improve integration. The obligation to affirmatively further fair housing goes beyond simply identifying impediments to housing choice and requires active measures to mitigate those impediments to housing choice. So what do we mean when we talk about barriers to housing choice? Well, obstacles or impediments to accessing housing might be things like having occupancy limits on the number of people that can live in a property that are well below the threshold that would be expected based on health and safety or building codes. It might be things like restrictive zoning or offering residency preferences for affordable housing developments in communities that are already segregated. Accommodating community opposition to affordable housing based on unsubstantiated fears about neighborhood character or detrimental effect on schools might be a barrier to housing choice. Similarly, lacking a functional housing discrimination complaint process can be a barrier to housing choice. One of the most powerful tools available to a recipient of federal funding to meet its obligation to affirmatively further fair housing is to engage in affirmative marketing. What is affirmative marketing? It's the practice of providing targeted information about program opportunities to groups of people who are otherwise least likely to apply for those opportunities. Affirmative marketing is intended to actively promote residential choice and integration. It's about helping people overcome legacies of exclusion. One of the first questions is, how do you decide which groups to target? Well, affirmative marketing targets groups that are least likely to apply. Least likely to apply means that there is an identifiable presence of a specific demographic in the housing market area, but members of that group are not likely to apply without targeted outreach, including marketing in languages other than English and offering alternative formats for disabled people. Reasons for not applying might be insufficient info about housing opportunities, language barriers, transportation impediments. There are multiple types of strategies that an organization can employ to undertake affirmative marketing. One is focusing on the types of data that are presented, presenting data on school quality, services, other neighborhood features, information that minority communities may not generally have access to, information that's designed to address gaps in knowledge that result from decades of residential exclusion. Methods for outreach may include placing advertising in mainstream news sources, as well as regional, local, and minority news sources. Basic newspaper ads will be insufficient to expand residents' horizons beyond the status quo. Outreach for affirmative marketing needs to be intentionally structured to show people that there are appealing alternatives to the status quo. When identifying media outlets, consider each reason for choosing individual outlets and the language of an advertisement. Consider alternative formats to reach people with disabilities. Use targeted mailing lists to reach members of protected classes. Conduct informational meetings during weekend and evening hours to educate applicants about the application process. Incorporate mechanisms like organized visits or tours to ensure that prospective residents can gain personal exposure to the resources available. And engage local groups in the process. Identify social service agencies or community groups that serve targeted populations and can be collaborators in the affirmative marketing process. The last thing to consider is having a plan in place to evaluate the effectiveness of marketing activities. have a process to determine whether those affirmative marketing activities successfully attracted individuals identified as least likely to apply. If not, adapt and revise each plan accordingly. A federal grantee can also demonstrate that it's meeting its obligation to AFFH, or Affirmatively Further Fair Housing, by making vital documents available to LEP persons. LEP means limited English proficiency. This includes providing timely interpretation. It also includes written translations. Other ways to affirmatively further fair housing include publicizing fair housing information, working with advocates in the community to increase integration, perhaps undertaking enforcement actions, promoting diversity, and, as needed, amending zoning ordinances. HUD will be changing some of the requirements associated with affirmatively furthering fair housing. There is currently a proposed rule that is making its way through the system. This proposed rule will require that recipients of federal funding undertake an assessment of fair housing, or an AFH, that is primarily designed to improve integrated living patterns. The consequences for failing to affirmatively further fair housing are not insignificant. These consequences can include the loss of any federal funding, as well as other monetary penalties or judgments if an entity is sued. Some examples of this include a lawsuit against the County of Westchester in New York. So to recap, the Fair Housing Act and FEHA lay out protections in housing based on race, color, national origin, religion, sex, disability, familial status, sexual orientation, marital status, source of income, and ancestry. There are several other California state laws that complement these fair housing protections. The Unruh Act, which we mentioned earlier, prohibits discrimination by any business establishment. This applies not only to housing providers, but to any business. The Unruh Act covers discrimination against all classes protected under state fair housing laws. It has also been interpreted to prohibit discrimination on the basis of any arbitrary characteristic. A person who is alleging a violation of the Unruh Act may file a complaint with the California Department of Fair Employment and Housing, or DFEH. In California, we also have specific protections against overly restrictive occupancy standards. It is lawful to restrict the maximum number of occupants in a rental unit in accordance with health and safety or building code requirements. However, health and safety or building code requirements are extremely permissive. For example, the Universal Building Code states that 120 square feet plus an additional 50 square feet for every extra person is sufficient for building code purposes. DFEH has published an occupancy guideline to help ensure that housing providers do not implement occupancy standards that restrict the ability of families with children to find housing. The DFEH guideline is called a 2+1 standard. This means that DFEH recommends 2 people per bedroom plus 1 extra person. So for a 2-bedroom unit, for example, the occupancy restriction would be 5 people. In California, anything that's more restrictive than the 2+1 standard will be presumed to be discriminatory against families with children. There is a legitimate business exception, which would be a justification for having a more restrictive policy in place, such as septic tank capacity or building code compliance. Several other specific considerations in California related to families with children. One is for any public housing unit, any adopted or foster children should be considered members of the household for composition purposes. The other thing to bear in mind is ensuring that community rules are not enacted so that they have a disparate impact on families with children, meaning they're facially neutral, that community rules are not specifically aimed at families with children, and that they're evenly applied in a way that is not just applied to families with children. The California Government Code has two provisions that are related to minimum income requirements that have some fair housing implications. Under the first provision, if a housing provider uses minimum income requirements, meaning showing that a tenant has to earn 3 times the monthly rent, for example, to qualify for a property, then a housing provider must prorate that minimum income requirement for voucher recipients so that the income requirement is proportionate to the amount of rent that the recipient of the voucher actually pays. The second government code provision with fair housing implications states that if a housing provider uses a minimum income requirement and allows married couples to combine their incomes to meet those requirements, then the housing provider must also allow unmarried cohabitants, like same-sex couples or roommates, to combine their incomes. This ensures that tenants are treated equally regardless of marital status or sexual orientation. The Ralph Civil Rights Act is another California state law with fair housing implications. The Ralph Act prohibits threats, assault, or harassment based on membership in a protected class. This is in effect hate crimes legislation. It does not apply only to housing providers. For example, a victim of a hate crime may file a complaint against a neighbor for vandalizing her garage door with racial slurs. This law provides for statutory damages. A person alleging a violation of the Ralph Civil Rights Act may file a complaint with DSEH, the California Department of Fair Employment and Housing. Because disability discrimination complaints make up the bulk, nearly half, of all complaints lodged with HUD, we find that it's valuable to talk specifically about disability discrimination and reasonable accommodations. There are 3 laws that build in protections for people with disabilities in housing. The Fair Housing Act and FEHA, which cover most housing, plus the Rehabilitation Act and the Americans with Disabilities Act. The Rehabilitation Act applies to federally funded housing, and the ADA protects the rights of people with disabilities in government properties and public accommodations. The discussion of disability starts with the definition of disability. To be disabled for purposes of fair housing law, an individual must have a physical or mental impairment which limits a major life activity. Federal law requires a showing that the impairment substantially limits a major life activity, but the standard under state law is less onerous. Under state law, an individual is disabled if he or she has an impairment that simply limits a major life activity. Physical or mental impairments can run the gamut, ranging from physiological disorders or disfigurement to mental illness and learning disabilities. Alcoholism is considered an impairment for purposes of fair housing law, regardless of whether the individual is currently using alcohol. Similarly, substance abuse is considered an impairment for purposes of fair housing law. However, people who are current users of a controlled substance are not protected as disabled by fair housing law. One rule of thumb for determining whether somebody is protected as a former user or addict is whether they've gone through a formal treatment program and can document that they've been through treatment. Major life activities include the daily functions of normal life: breathing, walking, seeing, learning, working, self-care, manual tasks. So, if a person has an impairment that limits a major life activity, then that person will be considered disabled under fair housing law. This is a different standard than that used by the Social Security Administration, for example. People with disabilities are protected against discrimination on the basis of those disabilities, like refusal to rent or offering different terms or conditions, as we discussed earlier. But fair housing laws also explicitly entitle people with disabilities to request reasonable accommodations or modifications. A reasonable accommodation is a change or exception to a housing provider's regular policies, practices, or services that is necessary to provide a person with a disability an equal opportunity to use or enjoy her home. A reasonable modification is a parallel concept. It is a structural modification to the interior of the existing premises that is necessary to ensure an equal opportunity to use and enjoy a home for a disabled person. The threshold requirement is that to request a reasonable accommodation, a tenant or an applicant must be disabled under the definition just discussed, and that the policy change or the exception the disabled person is requesting must be necessary to mitigate the effects of that person's specific individual disability. The purpose of reasonable accommodations or reasonable modifications is to level the playing field for people with disabilities and provide them the same access and the same opportunities in housing as people without disabilities. For both reasonable accommodations and reasonable modifications, the initial burden falls on the tenant. There's no requirement that a housing provider proactively anticipate the need for an accommodation or a modification. To make an accommodation request, a tenant has to do two things. One, establish that she is disabled, that she has an impairment that limits a major life activity. And two, adequately explain why the specific accommodation she is requesting is necessary because of her disability. A tenant is not required to provide unfettered access to her medical records or a laundry list of diagnoses, but she should provide sufficient detail to adequately describe the impairment and the limit on a major life activity. A tenant should also explain how the change or the exception she's requesting as an accommodation will help to mitigate the effects of her disability. A tenant is not obligated to make this request in writing. She can communicate it in conversation. There's also no requirement that the tenant use the phrase reasonable accommodation in order to trigger a fair housing obligation. The question is whether a reasonable person would understand the request to be related to a disability-related need. Once a tenant makes a reasonable accommodation request, the burden then shifts to the housing provider. First, if the tenant does not establish that she is disabled, meaning her disability is not known or apparent, and she didn't describe an impairment that limits a major life activity, or if the connection or the nexus between the disability and the accommodation she's requested is unclear, then a housing provider may request verification from a knowledgeable third party that, 1, the person is disabled, and 2, the accommodation she's requested is necessary because of that disability. Knowledgeable third party means a person with specific and individualized knowledge of the extent of a tenant's disabilities. It means they have subject matter expertise beyond any regular person on the street. It's usually a doctor or a nurse, but it can be a therapist, a social worker, a non-traditional medical provider. A housing provider may not ask a tenant specifics about his or her disability. Questions that are narrowly focused on how the impairment limits major life activity and how the accommodation will mitigate this limitation are allowable under the law. If the tenant establishes her disability and a clear nexus between her disability and the accommodation she's requesting, then a housing provider is obligated to undertake a 4-part analysis to determine whether her request is reasonable. The definition of reasonable is not subjective. It's clearly defined under fair housing case precedent. The first question to consider in whether a request is reasonable is if granting the request would cause the housing provider to incur an undue financial burden. This is determined through a cost-benefit analysis, weighing the benefit to the disabled tenant against the cost to the housing provider. Accommodations are policy or service changes. There's generally no cost or nominal cost associated with making an exception to a policy. Modifications, on the other hand, can be more expensive. But in market rate, unsubsidized housing, the tenant is responsible for paying for interior modifications. So, an example of this. If a tenant requests a reserved parking space because she has a mobility impairment and can't walk very far, there is no cost to make an exception to a first-come, first-served parking assignment policy. Thus, that request would not be unduly financially burdensome. The second question to consider is whether granting an accommodation request would cause a housing provider to incur an undue administrative burden. An administrative burden is a substantial increase in time or complexity in tasks required to be performed by the housing provider in order to grant the accommodation. For example, changing the rent due date from the first to the third for a disabled tenant who relies on SSDI payments as their sole source of income. Changing the rental due date would not be an undue administrative burden because it would not be a substantial increase in time or the complexity of tasks. The next question to consider is whether granting a request would require a fundamental alteration in the nature of the housing provider's services. This means it's a change so significant that it alters the nature of the housing provider's business. For example, a disabled tenant requests transportation services from the property management company. If the property management company does not generally provide such services, then that type of request would be unreasonable because it would be a fundamental alteration. The last question to consider is whether an accommodation request would create a direct threat to the health, safety, or quiet enjoyment of others. It may not be reasonable to accommodate a tenant that would threaten other residents, but the threat must be documented and verifiable, not speculative. For example, a landlord may not deny a tenant's request for permission for a service dog simply because the dog is a German Shepherd, and the landlord believes German Shepherds are a dangerous breed. However, a landlord may deny a tenant's request if she was evicted for cause from her last apartment because her service dog attacked the mailman and the maintenance man. This is documented in a police report. Even if a housing provider determines that a request is not reasonable because it constitutes an undue burden, a fundamental alteration, or a direct threat, the conversation doesn't end there. Housing providers are obligated to engage in an interactive process to reach an acceptable alternative accommodation. The housing provider should notify the tenant or the applicant of the reason for determining the request is not reasonable and ask to discuss alternatives. Other things to keep in mind. For reasonable modifications, a housing provider may require that the work is done with all applicable permits and performed in a workmanlike manner. But a housing provider may not require that a tenant restore the premises to their original condition and move out unless the modifications would interfere with the enjoyment of a future tenant. For example, a tenant who lowers countertop height to accommodate a wheelchair might need to restore at move out. But a tenant who installs wood flooring instead of carpet to accommodate a wheelchair is likely not obligated to restore at move out. A housing provider may never require restoration to original condition for modifications made to common areas. For example, a ramp installation at an exterior door. Those are modifications that comply with general accessibility requirements. Finally, if interior restoration is required, then the funds to pay for that restoration should be held in an escrow account. One issue that often comes up in any discussion of reasonable accommodations is that of assistance animals. First, it's important to distinguish between service animals and emotional support or companion animals. A service animal is defined under the Americans with Disabilities Act. A service animal is a dog or a miniature pony that has been specifically trained to do a specific task for a person with a physical disability. Service animals are permitted in any public accommodation, meaning any facility that's open to the public. Disabled individuals may bring their service dogs on buses, into restaurants, into movie theaters, grocery stores, and so on. But the Fair Housing Act, not the Americans with Disabilities Act, is a law that applies to housing units. And the Fair Housing Act does not specifically define service animals. The Fair Housing Act instead provides that disabled individuals may request reasonable accommodations, one of which may be an exception to a no pets policy in order to have an assistance animal. An assistance animal may be a service animal, as defined under the ADA, or it may be an emotional support or companion animal. Emotional support or companion animals are not restricted by breed. They can be cats, birds, lizards. They're not restricted by size either. General weight limits for pets will not apply to emotional support animals, for example. Emotional support animals are not required to be trained to do a specific task. That's because the role of an emotional support animal is to address the effects of a physical or mental disability, often mental illness, by its very presence. A disabled person must explain how that individual animal ameliorates the effect of the impairment that limits major life activity. Other things to note about assistance animals. Housing providers may not charge pet rents or pet deposits for assistance animals. Fair housing laws classify assistance animals as tools, not pets. They're the equivalent of a wheelchair or a walker. Any damage that's done by an assistance animal would be recovered through the same mechanisms as any other type of damage to the premises caused by a tenant, which is deduction from a security deposit and possibly a small claims court suit. It is reasonable to have a basic agreement in place regarding an assistance animal, such as agreeing that the tenant will be responsible for disposing of its waste, that the animal will be curbed or leashed in common areas, and that the tenant will ensure that they abide by general community quiet hours. Some examples of reasonable accommodations may include a public housing authority granting a 2-bedroom Section 8 voucher to accommodate a live-in caregiver for a single disabled person. A housing provider who allows a transfer to a ground floor unit for a tenant with mobility impairment. Providing an extension of time to move for a tenant with severe physical disabilities. Other examples include offering assistance in completing an application for a prospective tenant with a cognitive impairment, or accepting a reference from a social worker instead of a former landlord for a prospective tenant who was recently hospitalized. Examples of common reasonable modifications include things like installing ramps or grab bars, replacing carpet with laminate or hardwood, and widening doorways. There are several best practice tips to keep in mind with respect to reasonable accommodations. Remember that reasonable accommodations are highly individualized and looked at on a case-by-case basis. A disabled person may request multiple varied RAs over the course of her tenancy. But also bear in mind that reasonable accommodations are only required for people with disabilities. If the nexus between the disability and the request itself is not clear, request verification. If the request would not impose an undue burden or a fundamental alteration, then grant that request. And in the event a request is not reasonable, be sure to engage in the interactive process to reach an acceptable alternative. Another best practice is to document all exchanges with the tenant, provide ample opportunity for the tenant to supply additional information if he or she chooses to do so, and maintain records of the entire process. The Fair Housing Act also has accessibility requirements that are applicable to any dwelling units constructed after March of 1991. For buildings with an elevator, all of the units must meet the accessibility standards. For buildings without an elevator, only the ground floor units must meet these standards. Requirements include having accessible ingress and egress, light switches at a height that are accessible for a person in a wheelchair, walls that are adequately reinforced to support grab bars, and kitchens and bathrooms with sufficient room to maneuver a wheelchair. Architects and builders may be liable for construction that does not meet these accessibility requirements. two other laws protect people with disabilities in housing: the Rehabilitation Act and the Americans with Disabilities Act. Section 504 of the Rehabilitation Act prohibits discrimination on the basis of disability in any housing that receives federal financial assistance. This means public housing, complexes with federal subsidies for the elderly and disabled, and programs for the homeless. Section 504 does not apply to private landlords who simply accept Section 8 vouchers. The Americans with Disabilities Act also prohibits discrimination on the basis of disability. Title II of the ADA applies to all public entities, such as public housing authorities. Title III of the ADA applies to privately owned public accommodations, like movie theaters, restaurants, stores, motels. It covers leasing offices and community rooms for housing providers, and requires that public accommodations be accessible to people with disabilities. This part of the training is about the administrative complaint process, or what happens when things go wrong. Individuals, private organizations like Fair Housing and Marin, government agencies such as HUD or the Department of Justice, and groups or classes of people have standing to file a fair housing complaint. Individuals include victims of direct discrimination, but also potentially people who have been damaged by discrimination in a more attenuated manner. An example of this was a lawsuit filed in 1970 against the owners of Park Merced Apartments, which is a large rental complex in San Francisco. The lawsuit was brought by a white resident who alleged that the housing provider engaged in a number of practices designed to keep minorities from moving to the complex, and that as a result, the white resident lost the social benefits of living in an integrated community. There are two possible forums for a fair housing complaint: court or an administrative agency. An injured party can file a lawsuit in federal or state court within 2 years of the date of harm. Or they have 1 year to file an administrative complaint with HUD or DFEH. It can be helpful for a housing provider to know what to expect in the administrative complaint process. Complaints are initially evaluated by HUD or DFEH's intake department. Intake determines whether a complaint is jurisdictional, meaning whether it establishes that the complainant is a member of a protected class and alleging that a housing provider engaged in a discriminatory act because of that protected class. The intake department will also look at the timing of the complaint and determine whether it fits in with the statute of limitations. If a complaint is jurisdictional and timely, it will be served on the housing provider, who's called the respondent in this process. The housing provider will have the opportunity to provide a written response to the complaint allegations. HUD will usually keep complaints that involve federally funded housing providers, but will transfer most other complaints to DFEH. Once a complaint goes through intake, it's then assigned to an investigator, who conducts a thorough investigation. Investigators have the power to subpoena documents, interview witnesses, and conduct on-site visits. The investigation is supposed to take no more than 100 days, but in practice, we find that it often extends from 3 to 12 months. At the conclusion of the investigation, HUD will issue a finding of either cause, meaning there is sufficient evidence of a violation of a fair housing law, or no cause. If there is no cause, then the case is closed. If there's a cause finding, then the case will be transferred to HUD or DFEH's legal department for prosecution. There are numerous opportunities for settlement during the investigative process, including formal mediation or conciliation, which happens concurrent with the investigation. Settlement terms may include things like tangible relief, like moving into an available unit or rescinding a notice to terminate, as well as monetary damages, changing a discriminatory policy, or undertaking training. If a complaint is caused and transferred to the legal department, it may then be filed in court as a lawsuit, Even once the complaint is with legal, however, there continue to be opportunities for resolution. An added incentive to resolve is that if a case is with DFEH, DFEH can now recover its attorney's fees from the housing provider in the event that DFEH prevails. There are several other possible outcomes to the administrative complaint process. For example, the Department of Justice may intervene in fair housing complaints that raise issues of general public importance or demonstrate a pattern or practice of discrimination. The Department of Justice is often interested in impact cases. An example of this was a suit in Bakersfield, where the property owner operated dozens of rental complexes across Bakersfield and sexually harassed more than 25 female tenants and applicants. He made unwelcome sexual advances and comments, he exposed his genitals, he touched women without consent, granted and denied housing benefits, and retaliated against women who refused his sexual advances. In this case, the Department of Justice intervened, and the resulting settlement was for more than $2 million. Injured parties may also file a lawsuit directly in court. There is no requirement of filing an administrative complaint with HUD or DFEH first. In a lawsuit, a plaintiff may recover actual and punitive damages, attorney's fees, and injunctive relief. The final portion of the training focuses on setting clear and consistent policies to ensure compliance with fair housing laws. The most significant best practice to have in place is setting clear and consistent policies and procedures to avoid even raising the inference of housing discrimination. Examples of the types of policies to consider: returning messages from prospective tenants. Are voicemail messages regularly culled from the system? In what order are calls returned? Is front office or leasing staff bilingual as needed to meet the language needs within the community? Are calls documented in a phone log? In terms of evaluating applications for tenancy, is it first come, first served, or does management collect a batch of applications when deciding who to rent to? What criteria is in place? Is that criteria reasonably related to a person's ability to pay the rent on time and take good care of the property? Responding to repair requests. How are repair requests processed? Is there a standard? Responding to discrimination complaints. If tenants complain that a staff member is discriminating, is there a process for investigating that complaint? If tenants complain that another tenant is discriminating, is there a process for determining what's happening? Managing wait lists and evaluating a lottery system versus a first-come, first-served system. Providing information to prospective tenants generally. Is there a basic script that leasing agents are asked to follow? Are all interested parties offered the same information and asked the same questions? How does the housing provider keep track of prospective tenants? Is there a log with contact information and date of inquiry? What about responding to reasonable accommodation requests? Is the housing provider documenting interactions in writing, providing a timeline for a response? If one tenant asks why another person has a dog in a no-pets building, is there a standard policy of saying, we appreciate your concern, but in this situation we are complying with all applicable state and federal law? What about community rules? Are they reviewed to ensure that they don't treat residents differently based on familial status, for example? With respect to tenant files, is there a policy of maintaining copies of all written correspondence, including rent receipts, notices, complaints received, and actions taken, and a general communication log? These are the types of policies and procedures to consider to ensure that fair housing liability is limited. The second thing to consider is providing regular fair housing training for all staff, including anyone who touches the housing transaction, such as maintenance staff, administrative employees, and off-site owners. Displaying equal housing opportunity material can be very powerful as well. Remember that housing providers are legally entitled to ask about convictions for manufacture of a controlled substance. They're also entitled to request information that demonstrates whether an applicant will meet the tenancy requirements. Can the applicant pay rent? Can the applicant comply with the lease terms? With that said, housing providers should be open to accepting alternative methods of demonstrating tenant qualifications. For example, an inflexible policy requiring Social Security numbers may constitute national origin discrimination. If the goal is to have tenants demonstrate a positive credit history, then housing providers should accept ITINs or other methods as appropriate. It's not incumbent on the housing provider to automatically suggest alternatives, but a landlord should be open to all reasonable alternatives that are suggested by the tenant or the applicant himself. It is also important to note that fair housing laws do not protect people who are a direct threat to the health or safety of others or would substantially damage the property of others. The following resources may add additional information if you have outstanding questions about fair housing.